The Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. This court, from recess, now sitting.
Thank you. Please be seated. Now call the third case on this morning's docket. That is case number 104083, State of Kansas v. Stephen Bernard Foster.
May it please the Court, I'm Heather Cessna with the Appellate Defender Office here on behalf of Mr. Foster, and I would like to request 4 minutes for rebuttal time, please.
4 minutes is granted.
Thank you, Your Honor. Obviously, we're here on sort of a different side of the same statute on the issuing or delivering in the forgery statute. I just wanted to share with the Court this morning that as I was preparing for argument, I had a distinct memory from law school where I was sitting in a lecture on negotiable instruments and thought how happy I was that I had decided at that point that I was going into criminal law so that I would never have to look at the UCC again. So on that note, let's talk about the UCC definitions.
Well, let's talk about that, negotiable instruments, because forgery involves a broader spectrum of written documents, does it not?
That is correct, Your Honor, and that was actually one of the first points I wanted to make this morning. Obviously, in this case, the specific instrument that we were talking about in this case was a check, which falls under the negotiable instrument venue. Our argument, however, is that the language of the forgery statute actually is broader than that. It includes written instruments, which includes negotiable instruments, but there are certainly other things that are written instruments that are not necessarily negotiable instruments. So, I mean, our first problem with the use of the UCC definitions in this case is primarily based on the fact that if the legislature had intended us to use those very statutorily specific definitions, I think they could have used that language appropriately, and the fact that they did not, I think, is a perfect example of why they probably were not intending us to be that narrow of a definition.
It's narrow, it's civil, it's not criminal.
Right.
But even if we do agree with you, why isn't issuing and delivering two different ways to say uttering?
Well, and I think this gets into the question under Brown, and obviously, I mean, we filed the 609 letters, referring to Brown since this petition was taken prior to that kind of clarification. And I guess the point that I wanted to make as far as our reliance on these recent cases, and obviously I have had the benefit of already being up here once this week on a similar issue in another statute. I think our reliance on the actual formatting of the statutes, while certainly that can be helpful and it can be somewhat instructive, I think we need to be very careful not to put too much undue influence on the way that these statutes are formatted, particularly in statutes like this where these formatting issues have come around prior to.
Let's go back before Brown.
Sure.
And when the criminal code was adopted, I think there were something like 20 different statutes that dealt with various aspects of forgery or forgery-like conduct that were all wrapped into this, what we're looking at now. And they used the a number of them used the archaic term uttering.
Mm-hmm.
Okay. And so why can we say they didn't intend on this particular subsection, when they consolidated all of those, they wanted to wrap it up and say, we're not going to make the jury split these hairs. This is criminal conduct to utter a forged document, whether you issue it or deliver it, you've uttered it.
Well, and I guess, and this is, I don't have a short answer to that, so let me kind of explain here. I think our answer to that is that even with the subsections broken out the way that they are, I think even this court in Brown talked about the idea that if the conduct is so different that it could still constitute alternative means even if it's getting towards the same general conduct. Again, I go back to the language in Brown that refers to the Washington case, I think it was Peterson, that talks about their theft statute, and that the conduct that was covered by both alternative means and the theft statute, even though it's still getting to the general concept of something being illegally taken, it's still the conduct involved is so different. And so my answer to your question, Justice Johnson, is that the conduct contemplated by issuing and delivering, even though it's contained in the same subsection, actually is significantly different. And I think even from a general definition, without going into all the UCC definitions and all that, I think that the concept of delivering a forged instrument as opposed to issuing is sort of the difference between losing possession or control in the case of a delivery versus something like publishing or publicizing it in the case of issuing. And I would argue that those are such sufficiently different acts that even if they're contained within that...
Explain the difference in the acts with regard to a check.
Well, and I think the difference there is that you can... I think the difference that we argued in this case specifically to the checks is that if you're delivering or you're losing possession or control of it, you're essentially turning it over. I mean, you can get into the specifics of whether you're like endorsing it to give it to the check smart people like was in this case or something of that nature, as opposed to perhaps using a forged check to publicize or show somebody that you've been given this amount of money without necessarily still losing control of the actual document itself. And maybe, I think this is, let me give you a slightly different example, perhaps to sort of help draw that distinction. I think, for example, if you were going to take like a forged car title or something, taking the forged car title to the county treasurer's office to show them that you have this title that's not really yours, in order to obtain illegal tags would be something along the lines of issuing or publicizing or publishing this without actually losing control, versus actually then signing it over and purporting to sell, or turn the title over to somebody else that you don't. That would be more along the lines of delivering. And I think it's probably not as common in a check situation to have the issuing part of this, and that's why our argument in this case is that there was evidence of delivery here but not of issuing. And so, but I think there still contains such different acts that even under the Brown analysis, and in spite of what would otherwise be the problematic formatting for us in this case of the forgery statute, I think that those acts are still significantly different to constitute alternative means. Does that help kind of clarify our argument?
Not really, but...
Well, that's not a good sign. I think the bottom line that we wanted to make up here is that I think there's a whole host of problems with using the UCC definition. So I think we definitely have to step away from the Court of Appeals opinion on that factor, because the written instruments are such a broader category than just negotiable instruments. And I think the Court of Appeals got hung up on the fact that there was a check in this case, and that would constitute a negotiable instrument. So I think that's part of where some of that bleeding over came in this case. I think forgery is covers too many wide array of issues for that.
So where do we get the definitions of issuing and delivering?
Well, Your Honor, I think even the state conceded in its original brief that, this court has consistently held that in cases where perhaps the plain language of the definition is not entirely clear, that you have to err on the side of the defendant and use what would be the common or ordinary meaning of the words. And I think, we picked the definition from the Black's Law Dictionary in part because I know that we've regularly utilized that, and it seemed like it was a more commonly accepted definition than some of the very specific things that are applied for in other dictionaries. But certainly there's a host of dictionaries we could choose from and talk about, I suppose. Black's Law was what we
wouldn't you agree in the area of forgery that the origin has got to be the archaic term uttering? That was the term that was always used with respect to forgery until they modernized it and said issuing or delivering, but uttering would have included everything that you've said for both definitions, would it not?
Well, and I think you're probably far more versed on the old statutes on this than I probably am. So I will take your word for that, I suppose. But I think that my concern with the lending too much credence to the way that the legislature has formatted these statutes is that I think we've seen time and time again where, and not to bash the legislature when they're not here to defend themselves, but I think that we've seen time and time again where even in cases where everybody knew exactly what they were trying to do, and just off the top of my head, I'm thinking of something like the Fraser fix in the Snelling's case, everybody knew what they were trying to do, and they still didn't manage to accomplish it correctly. And so I think that while the formatting and putting these into separate subsections can be helpful in some cases, I think we have to be careful not to, perhaps give them more credit than they've necessarily shown themselves worthy of.
Well, let me ask you this
aspect.
then. Where the legislature has not defined those terms, is it appropriate for us to look at legislative history, if there is legislative history that's germane?
I think that can be one aspect of the consideration. I don't think that the state has put forth any particularly helpful legislative history on that fact, partially because I think they were putting all their eggs in the UCC basket in their brief at least. And unfortunately, we did not have the benefit of having oral arguments in this case at the Court of Appeals, so I think otherwise perhaps some of these questions might have been fleshed out a little bit better had we had this experience once before, which a lot of these petitions we often do. So I think we're a little hammered by that fact. But I think that's certainly a consideration. I'm not sure that I have a lot to add as far as making the state's argument on that for them. This court obviously took this one issue from our petition, so we would simply ask that that this court reverse the Court of Appeals opinion and expressly disavow the use of the UCC definitions as part of the theft statute, find that its alternative means, and vacate for insufficient evidence.
Any further questions of counsel? Thank you, counsel.
Thank you.
Good morning. May it please the court. My name is Jason Geyer. I'm an assistant district attorney, and I represent the appellee in this case. To be very brief and very blunt, the panel, the Court of Appeals in this case, got it correctly. And they got it correct for two reasons. Number one, they went to the structure. They tried to get the intent of the legislature, and then went to the structure of the statute, and they found the three subsections provided three different means. And in this particular one, we're talking about subsection A2. So I think the structure in and of itself, they got that correct. Secondly, I know that the state set forth in their brief, focused on the UCC, and the Foster panel adopted that. And again, I think they did the right thing in interpreting, issuing, and delivering. And as they pointed out, issuing is, according to the UCC, issuing is the first delivery of the instrument.
Negotiable instrument.
Negotiable instrument.
In the civil context.
Yes, but we are dealing with, in this particular case, a negotiable instrument. So I think it's perfectly logical and appropriate for the Foster court, to the Foster panel, to go to the UCC and adopt those definitions. I'd like to point out...
When you do that, aren't you going to have problems in future cases that don't fit negotiable instrument?
Problem may be a strong word. I would acknowledge
A challenge.
A challenge. I would acknowledge that if there was an instance of issuing or delivering that did not necessarily involve a negotiable instrument, it may be within the purview of a panel of the Court of Appeals or this court to look for a different definition. But in this case, when we are dealing with negotiable instruments, I think it certainly is appropriate. And I'd like to point out, I know in the petition for review, Mr. Foster is taking great issue with the panel of the Court of Appeals looking towards the UCC and adopting that definition. But in their original brief, Mr. Foster says, Kansas statutes do not define issue or deliver. Well, that's simply not true. We know it does in the UCC. Now, it appears in the petition for review, in some respects they're changing horses because they don't like that definition all of a sudden. So now it's inappropriate to look at the UCC. But then later in their petition for review on page 6, they again repeat the Kansas legislature, or excuse me, Kansas statutes. They don't say Kansas criminal statutes. Kansas statutes do not define the words issue or deliver. Simply not true. They do. Again, there's some amount of speculation here, but the fact that that was their initial complaint, or Mr. Foster's initial complaint, that those were not defined in Kansas statutes, implies that if those terms were defined, they would be satisfied with them, or they would accept those definitions. And in fact, we have found out that in the UCC, in Kansas statutes, those words are defined. So ultimately, again, the Foster Court got it right. I think if you go to the legislative intent, you can look at the structure of the statute, and you have 3 separate means, in A1, A2, and A3. Here, issue and deliver are a specific one means. They're not alternative means. And I think that's borne out by looking at the definitions in the UCC, which, in this case, the Foster Court appropriately did. And I'll stand for questions.
Any questions of council?
Other than the UCC, is structure enough for you to carry the day?
In this particular case, yes. And I think the Brown Court, and it's obviously not absolute, and this court in Brown certainly said that that's a place to look. In all cases, would the structure of a statute be sufficient? I can't say that. In this case, I would certainly argue that, certainly say so. And then I think the definitions in the UCC is applied here is, for lack of a better term, simply gravy, simply a cherry on top. But yes, I think in and of itself, the structure of the statute is perfectly fine in and of itself.
You said it might not be in another case. What would that case look like?
I don't know. Again, I'm sorry, Justice Beyer, that's speculation, and I think I'm paraphrasing from the Brown decision, and I believe it's this court that said that structure certainly lends itself to divining the intent of the legislature. I believe the Brown Court also said that's not absolute. So that's where I'm getting my argument that it's not always absolute.
Excuse me, I'm sorry. So in any individual case, the argument is just, or it's limited to what the person presenting the argument thinks, which way it falls in that case? I mean, can you give us any other guidance? Whether structure is persuasive or conclusive in any given case. Today you say it's conclusive today, might not be in another case. I'm just trying to figure out where the line is.
I don't know. I don't want to speculate on what that other case would be, and I would hate to say that it's...
Well, if you can't tell us what the other case would look like, why should we believe what you have to say about this case?
Well, I think the Foster Court did an appropriate analysis on that, and that is they looked, although this wasn't argued even in the petition for review, when you look at subsection A1, there are three different options within that one means. They use 3 different words.
In the last argument, we talked about creating.
Correct. Then there's the transferring, the possessing, each one. And I think the fact that those were set out in 3 specific subsections, and I think the Foster Court did a great job of explaining those are 3 options within one means. In subsection A1, 2 options, the issuing and delivering. I think that in and of itself is clear enough to say, hey, that's why the legislature did what they did in separating these into subsection A1, A2, and A3. I'm not sure if I helped you at all, Justice Beyer. But
Thanks.
Any further questions?
Yeah, what is the, using the Brown language, what is the distinct material element of the crime in this case?
Well, in subsection A2 in this crime, I would say it is the transferring of an instrument that has been altered, endorsed, made.
So issuing or delivering are 2 different synonyms for transferring. is actually the gravamen of the offense here, under subsection, what, B, or?
A2, I believe it is.
A2.
Yes. Yes, generally speaking, yes.
Excuse me. That's the actus reus, right?
Yes.
Any further questions of counsel? Thank you, counsel.
Thank you.
May it please the court, just to perhaps try to give a slightly better answer to Justice Johnson's question that he just asked. I'm taking this from the discussion of the Peterson case in Brown. I think the interesting thing to note in there is when they're talking about the theft statute, and this is the Washington court, obviously, they're talking about how theft is wrongfully exerting control or deceiving somebody, and that in both cases the offender takes something. And I guess that's the overarching, and I wouldn't say that that's the actus reus, because I think the actus reus for subsection 2 is actually the difference between transferring the actual control versus simply publishing. But I think the overarching concept, and in the same way that the Washington court talked in Peterson about theft statute there, is, where the theft statute was that the offender takes something. I think the forgery statute is that you're using something that you're presenting something that's not yours for some kind of gain. And I think that you're still doing something that is a significantly different act in subsection 2. And while certainly I can't stand up here and with a straight face make the argument that the way that the statute's laid out is not part of the analysis, because I think it is. I just think it's not the overarching and controlling end-all be-all of this analysis.
But the gravamen of your argument relies on issuing being synonymous with displaying, rather than issuing being synonymous with transferring. And obviously, issuing can involve a transfer of possession, just like delivering, like when the U.S. Treasury issues money, it transfers it.
And I guess the difference there is the retaining some manner of control.
But that doesn't always happen when you issue something.
Well, and I think it depends on what definition you're ultimately using for the issue.
Exactly, that's what I'm saying.
I think under our definition, that is the distinction between.
That was my question. We have to buy into your definition being a displaying is the synonym rather than a transfer or distribution. I
would agree with that you have to, in order to make that distinction, I think you have to have that be the difference in the two. And I think that the definition that we've provided does that. So I suppose if you're relying on some other definition that certainly neither I or the state have put forth, then that would be part of the analysis.
And can we look for just common definitions of those words, what we'll find in the dictionary?
Your Honor, I think the case law has made it clear that what we're supposed to be looking for is something that's along the common or general understanding. And certainly in picking these definitions out of Black's Law like we did, that's what we were trying to aim for. Because, and let me be clear, and part of the reason why I think this is important is because the legislature did use two different terms here, and we're assuming that they have to mean two different things in order to not render one of them being essentially subsumed by the other. And so I think
that's not true. Under Brown's analysis, that sometimes the legislature uses the disjunctive as descriptive terms to show synonyms. And if you have synonyms, these things all mean the same things, then they are subsumed within each other by definition.
And I suppose that's part of I think that's obviously part of the thing that we've all been struggling with in the cases since Brown, is trying to figure out where we use those general terms of statutory construction, where we're not supposed to be reading things out of the statutes, along with this idea that if it's an option within a means, then sometimes we kind of are. And so I think there's a problem there between those two tenets that we're supposed to be taking into account. And so under our reading and our definition, that's why I think we were using the definition that we were, is that we've tried to accomplish both of those things by giving both the meaning that the legislature probably intended, or that we argued that they intended, to both of the individual things without reading one of them out of the statute, essentially.
But here we don't have to do that, do we? I mean, don't we just have to say that in some way the definitions overlap, and that we're not going to require the jury to parse the differences between overlapping terms?
Well,
Because if this court issues an opinion, we have delivered that opinion. But as you say, there may be a different use of the word issue that is display. So why can't they coexist as one means? Why do we have to say they are alternative means when there's overlap?
Well, certainly you don't have to say that they're alternative means. I mean, it's our argument this morning that they are.
Why should we?
I would never say you'd have to. I think the difference here is that, I mean, and again, I go back to the difference in the conduct in this particular situation. I think we need to come up with a definition, and I think our definition provides that shows the significantly different conduct with that overarching, like I said, with comparing this to the theft statute in Washington, that you can still have that overarching idea without it, and still have those specific and distinct conduct to make it alternative means. And that's what I think the definitions that we've provided for do that in this particular subsection.
Any further questions of counsel? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this case under advisement.